So I'm going to share my PowerPoint, but I'm Brian Ponder. Most of you should know me. Let me share this screen. Let's see, let's use a slideshow. All right, very good. There we go. Welcome to the Credit and Zoom training. I'm Brian L. Ponder. I'm a New York licensed lawyer. And for those of you that I haven't heard, you're licensed state by state. So when you take, when you take the bar in whatever state, you're licensed in that state. And that's called the state court system. Then you have a completely different system called the federal court system, which is separate and apart from the state, and you have to get admitted into federal court. So in New York, for example, there are 4 different federal courts: Northern, Southern, Eastern, and Western District. So I'm in all those courts, and then some other courts across the nation, I'm also in there. I'm in court of Western District of Pennsylvania, Northern District of Florida, Northern District of Illinois, one of Wisconsin's courts, Colorado, Southern Texas, Eastern Texas, Northern and Southern District of Indiana. I think that's all of them. And I'm also in some military, criminal and appeals courts, tax court, all that good stuff. So yeah, I do all that. I'm an avid biker, both bikes, bicycles and motorcycles, scuba dive. We will see if we can get Ken into scuba diving when I see him down there in DR. And then, what's the last one? I like shooting. I'll shoot some guns. I don't hunt. I haven't hunted since I was a kid, but I like target practice. No kids, but I have a lot of plants at home that I have to try to water every day. And that's what I do. Can you all, let me see, can you all see? I'm just gonna scoot this over a little bit. There you go. Training is very important. We talked about this before. I usually don't have this slide. You're gonna have to invest. I know before I was a lawyer, I did what a lot of you do. I dealt with credit for, let me see, started 2005 to 2000. I started with credit 2005, and 2008 went to law school. And then after that, took the bar. As soon as I did that, I spent maybe a couple $1,000s just on books, NCLC books. You're gonna have to invest in your training and education. I can promise you, the more that you learn, the more that you earn. That's something I can promise. Let me see. Let me see. Let me ask Warren a question there. Hey, Warren, can you see the whole slide, or are the pictures blocking some of it?
It looks like the whole slide.
You can see the whole slide.
I see the training slide, and then on the right there it says, the more you learn, the more you earn.
Okay, but nothing's blocking it?
No.
Oh, okay, good. All right, okay, good. Okay, I'll just check. All right, so cool. Let's see where we're at here. This is what this is the picture Ken has me looking like right there. That's self-portrait. That's what Ken has me that. Ken, can we all just get along? Anyway, but this thing, so this lecture is how to sue debt collectors pro se and stay out of federal court. That court you see there. Now, in one of the previous lectures, I had a picture that I took last time I was at the court, but this is one I just took offline. The picture I used before is the Southern District. This is the Eastern District. So this is a court over there in Brooklyn. I've done a lot of cases there. Beautiful court, beautiful. If you've never been in a federal court house, I don't know if you necessarily want to, but it's, I'm just telling you, it's beautiful. It's beautiful. It's completely different. It's not crowded. Everything is scheduled. But if you get a chance, I want you all to at least try to, you can actually get in there. You can just go in there and just go to your local federal courthouse and just, have a seat, because court's open to the public. So they could be having a federal trial and you can just go in and sit in there. I just want you to get a feel for it. It's a beautiful place. and then go get a feel for your local state courthouse. Totally different. You'll see. And I'm gonna mute. We'll mute a few of you. Just unmute when you want to talk. So 4 steps to sue a debt collector. I just broke it down into 4 steps tonight, you all, so we can try to get through it. Number 1, you want to identify the violation. We'll keep it real simple. 2, you're going to send a demand letter and a CFPB complaint. 3, you're going to sue them in small claims court. All right. Now I'm going to tell you why. We're going to talk about it. You're going to sue them in small claims court. And it's a certain reason you want to do that. And then 4, you want to settle and prepare for trial. That's it. It's really, that's it. Those are the only 4 steps. We're going to go over each one tonight, and we're going to finish on time. Number 1, identify the violation. 2, send a demand letter and CFPB complaint. 3, you want to go ahead and sue at that point, obviously, if you don't resolve it by demand. And then 4, you want to settle or go to trial. Identify the violation. That's number 1. Now, it's several things that can be violated by debt collectors. We're just talking about debt collectors. Now, for those that are new, you're going to have to go into the Facebook group and look at the getting to know the FDCPA and understand what definitions are. But debt collectors are a certain type of people. Those are companies that collect debts that were not originally owed to them, that were owed to someone else. So a debt collector can also be a debt buyer if they bought that debt. A debt collector can also be a servicer of a debt if they start servicing it, after it defaulted or whatever the case may be. The FDCPA is 15 U.S.C. 1692. We'll take a look at that. Also, actually, we might jump over it now. Let's stay here, FDCPA. Some of you, for the new people, and everybody, let's think about some violations that can happen with a debt collector. Someone give me an example of a violation that we talked about recently that we can find to sue on with a debt.
Pulling the credit report without pulling the credit report.
All right, so let's do this. Okay, let me do this. Let's talk about FDCPA. Is that an FDCPA violation?
No, I think that's an FCRA violation.
Okay, right. That's an FCRA violation. So, but Derek, you are correct. That is a violation. That's a violation of what? Which section of the FCRA, Derek? Or anybody? Section 1681, A, B, C, or D?
I had Brown early tonight, bro.
Oh boy, y'all! Oh Lord,
Isn't it B?
1681B. So, but that's correct. But let's talk about some FDCPA violations. Give me an example of an FDCPA violation. Real easy. Let's just give me some basic ones we want to look for.
Adding on extra fees.
Adding an extra fee.
Harassment.
Harassment.
Calling before 8 a.m.
Or after what time?
9 p.m.
9 p.m.
Okay. That's correct. Give me some more.
Harassing.
Acquisition of location information.
Well, that itself is allowed, right?
Well,
but it's a right, like Keith Sweat. What did Keith Sweat say?
The right and the wrong way.
Who's that?
Third-party disclosure.
What's that?
Third-party disclosure.
That's right. So that's right. That's right, and that's almost akin to that third acquisition information.
Yeah.
You can do that, like Keith Sweat said. It's a right and a wrong way to acquire that information, and if you do it in the wrong way, like Jason said, if you're disclosing that person debt to a third party that's a debt collector or communicating about anything more than location information, that's a third party disclosure violation.
Threats of legal action if their next intent is not to pursue legal action against you.
Wait a minute, now Jason, where you from, Jason?
Actually, I've been in the industry for about 25 years. I was the former manager of a collection agency.
Hold on for a second. What color you like? Yellow, green, blue, orange, or red?
Give them
Red.
purple.
I don't have purple. See, he's what you call a veteran. Give us some more, Jason.
Calling several times during the day after they made initial contact, such as if somebody called you, you hung up on them, and they called right back, that would be a violation.
Repeated calls. And we're breezing through these. Typically, you'll see the previous lecture, we would comb through the FDCPA, but we're just picking out some violations so we can get through this. All of those things you're saying are violations. It's some more that we recently went over that I'm not hearing yet. And I want to see, can anyone?
What about the 5-day rule?
Okay, talk about it.
The 5-day rule that the initial communication needs to be sent to you. If not, they're in violation of the 5-day rule.
If you would be so kind to tell me what section of the FDCPA that is.
1692A?
No, that's way in the beginning. That's definitions pretty much. But so 1692G.
B.
A.
GA.
GA is regarding miscommunication. So tell me about the 5-day rule, if you would, somebody. What would be the violation? Like, I see where you're going, but what's the violation? I think you said it already, Yolanda. Can you explain it again, just in case?
Basically, they need to send you written communication within 5 days of contacting you, and if they don't, they're in violation. They have to give you a breakdown of the debt. They have to give you a breakdown of how much you owe. It's a couple things. I don't have it in front of me.
Is it a couple things? Is it 1, 2, 3, 4, or 5
It's
things?
5. I know it's 5, but I don't know all 5 of them. But they have to give you 5 things that are listed under that particular law.
All right. So their initial communication with you, does that 5-day rule start clicking if they call you, or do they have to write you first? Like, when is that initial communication?
They have to send that to you right away upon receiving that debt, being assigned that debt. It has to be 5 days upon whether or not they purchased the debt or they're being retained by a collection creditor. They have to send out notification within 5 days.
Okay, within 5 days of the initial communication?
No, actually the initial receipt, isn't it?
Okay. So it's actually within the first 5 days of their initial communication with the consumer.
Okay.
So they could sit on that debt, and Jason, I've even seen, you may have seen this, I'm sure, a debt collector will get a debt, report it to the credit, and never initiate any initial communication with the consumer.
Oh, absolutely. Yeah.
Okay. And so the reason why it's important to say that, Jason, is because if they never made initial communication, that 30 days under 1692 GB never began. So that clock officially, actually the 1692 GB clock really doesn't happen until after they give that particular notice under 1692 GA. Because technically if they never do that initial communication notice, you never really trigger that 30-day verification period of 1692 GB. But anyway, what we want to understand is, my main question was, and Jason makes a good point, that 5-day starts actually with the initial communication with the consumer. And so my question was, does initial communication mean a phone call or letter or either or?
Either.
From the debt collector to the consumer. Which one?
Either or.
Either or.
Either or. Either or.
A letter, an email?
That's initial communication. If they email you, that starts that 5-day clock. Because we had a case, one of the members in here got an email, and they're chomping at the bits waiting for those 5 days, and guess what? They never got a 1692 GA written notice with those 5 items, so they have a claim under 1692 GA.
I got a question.
Yes.
How can you prove it though? So they call you tomorrow,
Mm-hmm.
and you're saying, hey, I don't have a written notice. I know we went over that. You said it's on them to prove it. Is that when you ask if they say, well, we sent it, you ask who sent it, and then you ask for an affidavit of that person? Was that what we covered with that?
You are mixing up some things because, well, your question is, how do we prove that they made an initial communication?
Yeah.
Okay, well, you tell
No, that
me.
they sent the written.
Well, you want to prove that they didn't, right?
So that we can get the claim. Right, exactly.
Okay, because, I mean, sure, you do have to prove, think about it. So let's think about this. If we're going to say they didn't do, if they violated 1692 GA, we have to prove a couple things, right? One, that they made initial communication with you, the consumer. And two, that within 5 days of that contact, they did not send you a written 1692 GA notice, right?
Okay. Right.
So the burden is on you to prove those two. That's your case.
Okay.
So you have to prove that they made initial communication. Well, how are you going to do that?
Records.
What kind of record?
If they email, we got that record. And if
Okay.
they
Well, boom.
called you, okay, yeah.
If they called you, how you gonna prove that?
I think we called also about recording the phone call.
Voice recorder.
Yeah, I'm in a one-party state, I think. So I can record it. I got a record app.
Well, what if you didn't record the phone call?
You also have your phone records.
Yep, go to your AT&T.
Yeah, and if you didn't record it, is it safe to say when you have a hang up, if it's your cell phone, if it's any phone, if you have record of a 2-minute conversation, that's not a hang up. That's a contact,
Gotcha.
right, Jason? I mean,
Yeah, absolutely.
I mean,
Yep.
if you have a time lapse of a call, that contact was made. So
Yeah,
boom, there you
most
go.
definitely. And one of the key things that I always advise people on is make sure you keep thorough records. Have a notepad by you. Take notes while you're on the phone with them. Put them on speakerphone. If you have a second phone, record the call. If you're in a first-party state, it's totally legal. You know, if you're in a two-party state, all you have to do is say, by the way, just to let you know, this call is going to be recorded and all future calls are going to be recorded as well. That way they have to notate that. So.
Right. Good point. And keep in mind, if it is a call, they're going to give you, they're going to probably tell you this call may be recorded for quality assurance and all that. Yeah, mine too. You can just do it like that.
Absolutely.
You know?
And yeah.
So good job. So I really wanted y'all to understand that. And let me add this, is a formal lawsuit, a summons and a complaint sent by itself with no cover letter, not sent, served to you, is that an initial communication under 1692G?
No.
No.
No, it's not.
Oh.
What if it's a draft complaint that's not filed? Is that a
Yes.
yes, very good, very good. So
Yeah, actually the state of Minnesota does that quite often. You know, they don't initiate the lawsuits and they just send out documents that make it look like it's a summons and complaint. You still have to answer it accordingly, but no cases actually open up with the local court for that.
that's interesting.
Brian, can we sue in New York in small claims court?
Yeah. Yes, it's called city court, but yeah.
I'm in the suburbs and we have our small claims here. I'm in New York also in the suburbs. It's for landlord, tenant, and
you sure
evictions and that. But you can sue in New York in small claims.
Absolutely, absolutely. And let me just we'll try to make good time here. But let me show you real quick where that authority is, because sometimes and we're going to get to the court, but let's go to 1692. You go to 1692 K and scroll down to KD. An action to enforce any liability created under this subchapter may be brought to any appropriate United States District Court. What is that? That's federal court. United States District Courts, that's federal court. So when you see United States Court on something, that's federal court without regard to amount in controversy or, okay?
Or, okay.
You read or, so it can be there or any other court of competent jurisdiction.
Okay.
Okay,
Yeah.
so that really is any court. Now, if you're in the city court asking them for $20,000, $30,000, well, guess what? You're
Yeah, that
within
won't
that
work.
jurisdiction.
Yeah.
But if you in there asking them for $1,000, you're within that court's jurisdiction. The court's jurisdiction, those smaller courts, is usually a monetary limit. Now, of course, you're not going to go to housing court because that jurisdiction is just housing. But a small claims civil court, yes. And so if you ever run into an issue, you know, this allows it. Now we got another slide that's going to talk about how you can definitely get in there, but this is how the authority to get into any court. But you can't ask for too much money in those small courts because that'll be a problem.
Okay.
All right.
Hey, Brian, quick question. Which state do you sue? Like the state you live in or the state that the collection agency is at?
Good question. Actually, anyone know that answer to that one?
The state you live in.
You sue in the state in which you live. That's where you were offended at.
Okay, so I'm hearing the state. Is anyone saying where the debt collector is, or everyone saying where you are?
It's where you are, where
where you are.
You can sue where the debt collector is. Right.
So can we say is there A, where you are, B, where they are, or C, both? Which one y'all think?
A. C.
Hey, where the crime was committed.
I got 500 on C.
I say A, and give me my $500.
Yeah.
Oh, okay.
We're gonna split it.
Oh, okay. I got $1,000.
It's C, y'all.
Whoa!
You sue where you are. You sue where you are. Okay.
Hey, just type your cash app in the
What about where the contract was signed?
Say it again. I'm sorry.
Where the contract was signed.
You can sue there. Who's that? That's Richard.
Yeah.
Richard's man.
Well, what contract would I have with a debt collector?
Well, guess what? They're collecting on a debt that may be a contractual debt. Okay, so let's talk about that with Ken. Now, let me ask you this. Okay, so are we clear? You can sue them where you are, because that's where you hurt, or where they are. We got that, right?
Okay.
Because this lecture is about suing them. I want to take it a little bit further. Where can they sue you, Ken?
They can only sue me where I'm at.
Only?
Only.
How much money we got on that?
Yeah, they can't. They can only sue me where I participate. Otherwise, nobody would have no jurisdiction over me.
$5 on.
How much money that?
Huh?
You know what? You can sue anybody anywhere. No. I got to entertain it.
That's a good point, Ken. So here's my question, Ken. Where can they sue you? You said where you are, right? Live. Only.
They can sue you anywhere, but that don't mean that they.
Okay. See, Ken, we have lawyer. Where can they properly sue you, Ken? A debt collector.
Where I live at. Where we transacted business.
Wait a minute. Say it again.
Where we transacted business.
All right. Well, that could be somewhere where you don't live now. Hold on.
Well, it could be.
But which one?
With a debt collector, I ain't got no business with them fools.
I agree with that.
Look, they gotta sue you in the county what you stay in.
So
does it have to be the state or the county?
What's the question?
Does it have to sue in your state or the county? Could it be anywhere in the state or it has to be in the county?
Well, that's a good question, Ms. Jones. So we're gonna answer that real quick. So my question to Ken was, of course, this lecture is about suing them, but my question to Ken was, where can they sue you? It's important to know this because guess what? I got this case recently where they sued, real quick, they sued the person in one county, but she doesn't live there, and they end up moving it to another county. But anyway, 1692I.
Hey, 1692. I think the keys. Did you guys move it at all? No. The key was in.
So mute yourself, y'all, if you're not talking if you got stuff in the background. 1692 I, what does it talk about? Legal actions by debt collectors, and obviously by. So where you sue or get sued, that's called venue, everybody. Venue. That's where you sued or are getting sued. That's where the case is at. Any debt collector who brings any legal action on a debt against a consumer shall. So shall means it must be there.
Must.
So we playing chess here, right? So we got two things and we see or. Okay, so that means we got a couple options. So this is what, well, okay. In the case of an action regarding real property, bring the action only in a judicial district or similar legal entity in which the real estate is located. So a district is like federal courts can cover several counties, but if it's not in a federal court, it would be whatever city or county that the land is located. Or in the case not described above, they can only bring the action in a district where the consumer signed the contract. That's what Ken was talking about, that contract, right?
Mm-hmm.
Or where the consumer resides. Okay, so you see the difference? So you could live in, say you live in Cincinnati, but you sign the contract in Akron. Okay. I know you didn't sign it with that debt collector, but say if the debt collector bought it, like Midland, Portfolio. If you sign the contract in Akron, it's technically they could sue you in Akron or wherever you live at. Y'all got that?
Yeah.
If they don't sue you in one of those two places, what is that? That's a violation.
A violation.
Of 1692.
Wrong venue.
Wrong venue. That's a violation. Okay. That's a violation.
What if I live on a boat?
Well, well, your boat, well, wherever you reside, if they serve you when you docked on whatever wherever they serve you, that's where you residing. They got to figure that out. And technically, so, oh, that's a good question. Who asked that one?
Yo, I was messing with you.
Well, no, you people live on boats. So, like in New York, it's some people that live on that boat, man. They live on that boat, but that boat is docked there. So, when does it matter where that boat is at the time? Technically, I would say it's at the time. I would say at the time that's a tough one. It could be at the time it's filed or the time it's served, I would say, but that's an interesting question.
I would think that would be the time that it's filed, because
I think
if you're at a different place, you could file for improper venue and try to get dismissed on that.
I think so. I think you're right, Jason. I think that's correct. It's at the time of filing. Where you are served, personal jurisdiction goes there. But you're right, venue needs to be proper at the time of filing. Personal jurisdiction flows with where you're served. So that's good. So those are FDCPA violations. Let's talk about some FCRA violations by debt collectors. And you all already talked about it. FCRA is what? 1681, 15 U.S.C. 1681 at SEC. So tell me about some. Someone already mentioned, I know Derek mentioned it earlier. So give it to me. Inquiry, right?
Yeah, the inquiry, by debt collector.
Okay, that's one. That's a big one. That's a big one. Acquiring the credit report under false pretense, which is separate, but under false pretense, that's a crime. So, but obtaining the credit report without permissible purpose, that's 1681B violation. Is there another one? You remember there's some furniture issues too. So
not marking is disputed.
Okay. Not marking disputed, actually, Warren, is a FDCPA violation.
Oh, that's right.
Not marking disputed on a consumer reporting side is a FCRA violation, but with a debt collector, that's a FDCP violation for them. There are some S2 issues with furnishing where they could be furnishing false information, but it may not give a rise to a private cause, but it's still negligent of them to do that. So, so those are FCRA violations. So I just want y'all to know that the debt collector can violate the FCRA too, even though they're a debt collector. They're not a consumer reporting agency or an original creditor, but they do furnish information. They do full reports. And somebody has some typing that I'm getting. All right, UCC. How can we get a debt collector on a UCC violation? All right.
What if they, like in the case of a repossession, if they went there?
Exactly. The repo, if y'all remember us talking about repo, someone has is typing on iMessage, and I'm getting all the alerts on it. If you don't mind muting. That's right, Derek. So a repo issue, any repo issue would be a UCC violation under Article 9, Part 6. Can you give me 2 or 3 UCC repo violations?
Well, one would be, wouldn't it be like if they, let's say if the vehicle is parked in a closed garage and they open it to go in, wouldn't that consider be like a breaking and entering situation? Or,
well, that's disturbing the peace, but let me see. Someone is everybody. Let me see. I'm just gonna mute. Can everybody just mute them? Someone's just typing like murder she wrote. And,
That's what crazy. It's crazy. I hear it too.
I mean,
that's Jessica Fletcher.
I thought Jessica. I thought, did that lady die? I thought she was dead. It sounded like she's still living. She died, right? So yeah, repo. What you were saying, Derek, is correct. You can't breach the peace, but I'm looking for more clear-cut stuff. You got anything else? Because that's a dispute.
Would it be like, will one of the things be like not sending out the deficiency notice?
Yeah. So when do you have to send that out? So Jennifer, that's correct. The deficiency notice, yeah.
They once you request it, they have to prove that it's 3 notices that they have to send out. So the first notice is like the right for you to go back and recover the vehicle by paying the full balance or whatever it is that you owe them. And then after that point, they're supposed to send another notice telling you where they're going to sell the car, what time and place, and the venue and stuff. And then after that, the last notice is supposed to be how much they sold it for and all that good stuff.
Okay. So correct. Some easy ones for y'all to remember. A pre-sale notice. It has to be a notification prior to disposition of collateral. That's what they call it. But a pre-sale notice. All right. If you and the pre-sale notice has to say that they intend to claim a deficiency.
Hey,
okay.
What about, Brian, if they like people when they like defer payments and they're supposed to go back and amend the agreement with updating the terms?
Mm-hmm.
No, I thought they can't do that because then that'll change the contract. Because what happens is when you defer a payment, if you're on a 60-term contract and you defer a payment, your last payment will just be 2 payments, like a big payment. But if they change it, the terms, then you essentially change the contract.
Well, we talking about UCC, but a violation of the UCC would be not getting that not sending the pre-sale notice. And I think a couple of you may have said not sending You got a pre-sale notice, you got a post-sale notice. Now, do you have to send a post-sale notice?
Yes.
Well, I guess it depends, right? I mean, it could be yes. A yes would be a correct answer, and no would be a correct answer. When do they have to send a post-sale notice? At least two circumstances they have to send that post-sale notice for them to be able to collect, you know. One, think about it. If you request it, right?
Right.
And if you request it, how many days they have to send it to you?
What is it?
14. It's been a while
14?
since repo. Yeah, 14 days. The second circumstance where they have to send that post-sale notice is
if they got less.
Well, that's a deficiency. Yeah. Well, yeah. Well, yeah. If you got less, that means you have a deficiency.
Mm-hmm.
But you can get a deficiency. You can sell it for less. So the balance is 10,000, but you sell it for 7,000. They can just sit back and do nothing, and they're fine. They haven't violated it. If they sent the proper pre-sale notice, sold it for 7, the loan is 10. They have a 3,000 deficiency. If I just sit in my office here and do nothing, that's fine. But if the consumer requests that deficiency, they have to send it within 14 days. The second circumstance is they have to send it before they start collecting on it, trying to collect it.
Mm.
So if they sold it for 7 and you owed 10 and they put in the credit report when they update it that you owe them 3 and they have not yet sent you a calculation, explanation. It's called explanation of calculation of deficiency. Is that a violation? Yes. And so if you look at the repo lecture, we don't have enough time to go through it, but it says they have to send it within 14 days of a borrower's request or before they start an accounting. Basically,
Brian,
what's that?
I have a quick question.
Yeah.
I did a consultation today with a client. She had a repo on her report. She never got the car.
She never got it.
Yeah, so she signed the documents and went home, didn't like the term, called them to cancel. Look, the repo is on her car. Went back, the place is closed down. It doesn't exist anymore.
So here's the thing with that one. I would want to know more because what if it's not really a repo? What if it's just the balance of that loan?
But she never got the car though.
I understand that, but
it says repossession on the report.
Okay. Well, if it says repossession, then guess what? If they did not send her a pre-sale, then that's easy for me.
Okay.
If you call it a repo, let's play repo then.
And the place is, she said the place is not even there anymore.
That's cool. Cool. I know how to deal with that. You know how to deal with it too now. How you gonna deal with that? So, I mean, if you get a repo package, it shows you how to deal with it. But you tell me, Ms. Jones, I mean, is that a UCC violation? I mean, first of all, you got to inquire whether she got a pre-sale, post-sale notice and all that notices, right?
She got nothing. She said she signed the paperwork and changed her mind and called them to tell them that she no longer wants the car.
So what
Never
you
saw
gonna
them
do?
again.
Bad boys, bad boy.
I'm gonna send it to you.
Well, you can send them to me, but also, I mean, there's a repo. I mean, clearly that's not right because you can't claim a repo deficiency on a credit report. You collect them. So you didn't send me no explanation. Guess what? You violated me. Okay, right?
Mm-hmm.
So everybody cool? Because we got some violations. So I'm just giving y'all some violations. We, at step 1, we identifying them. We gonna get through. What time is it?
4 to 2.
How much?
It's 4 to 2.
Oh boy, we are right. Okay. So let me give you a quick lesson on federal jurisdiction. If you sue them in small claims court or any state court and only allege FDCPA, FCRA, and UCC, you know all those are federal laws. If you just sue them on a federal law, they can come into that court and remove that case to what court?
Federal.
The federal court.
Federal court.
Yep, that's called removal. Notice of removal. You can look that up. I don't want to burden y'all with looking at it too hard because that's a whole class. I mean, that's a whole. I'm talking about that's a whole semester of law school on understanding that. But just know that if you sue someone on the federal law in state court, they can remove it. And so you remember the lessons is how to stay out of federal court. Why do I want y'all to stay out of federal court?
It's worse.
Worse for who?
For us, I guess, because we don't know all the rules.
Yeah, it's worse for y'all. Now, do I like federal court?
Yeah.
Of course you do.
It's great for me because I know my way around it, like my apartment, you know? And it's clean, it's nice, it's pretty, it's scheduled. One fee, you pay one filing fee, and that's it. You in there, once you're in there, you ain't no fee, ain't no nickel and diamond. What Ken at?
I'm here, baby. I ain't going nowhere. I hear you. I hear all those G's.
That brown.
Nah, Ken's good. So listen. Let me see if anyone knows this. How can I stay out? This is the whole point of late lecture. How can I be sure these knuckleheads not go pull me out of small claims court to federal court? How can I avoid that?
Put a state claim. Put a state claim in it.
State claim.
All right, Vance obviously knows. He's been suing folks for too long, and Miss Jones knows. So yeah, you add a state claim in there, they cannot remove it. They cannot remove it.
I got that from your rewatch one of the videos today.
Oh, you did? Yeah, they can't remove it. So we're gonna add a state claim. What kind of state claim can we add?
Consumer protection law, just a state consumer protection law, or negligence under the state law. It could just be any state law that
That's right.
apply.
So many states, you just look up in your state. Like each state has credit reporting laws. Each state has debt collection laws. Most states may have a shadow of the UCC. So if you allege one of those, you are good to go. Defamation is like when they're reporting something on your credit, damaging your credit reputation. Defamation. Negligence, they have a duty under other laws to do something and they don't do it and it damages you. That's negligence. Okay, everybody good with that?
Yeah.
All right, we got through it. Ooh-wee. All right, number 2, send a demand letter and a CFPB complaint. Y'all know about that?
Yep.
What kind of demand letter can you send? We're dealing with debt collectors now. So
1692
GB.
1692 GB. Now we gotta show Ken what we talking about. Ken, you seen that 1692 GB letter that I do?
No, man, I ain't seen it, man.
All right, well, guess what? We're gonna let you see it.
Okay.
Who sang that song, Edwin? Let me see it. Let me.
Oh, I don't know, man. It's crazy.
Oh, okay. You don't know. All right. Well, we're gonna show Ken this 1692 GB letter, Ken. This thing right here, man. Whew. I know it looked like just some words, but
is this the letter that you recently, in the last 2 days, had a bunch of stuff removed and you posted it somewhere?
This
letter?
This is the consumer version of it. So I can pull up one from my law firm like you talking about. This is the let me see. You talking about
well, you didn't show the letter, you just showed the results.
Yeah, I showed the results, but to answer your question, I use this format letter, but it's actually completely different, but it's the same concept, except I do it with my legalese and some, I put some law in there. But this letter is for consumers to send, and it's called the 1692 GB letter because it triggers the 1692 GB if it's within a GB time period. If it's not within a GB time period, it still trigger the they have to mark it disputed. So, but it's a GB letter because it's really designed. It really has some of the requests that are permitted within the GB. So this is what it
is. This letter among the letters that are provided when one buys your book?
Yes, it is. Yes, it is.
Then I should have it. I should have it then.
You should have it. And we updated this, and this is the updated version, I believe. Yeah, this is the updated.
But I don't have the updated version.
Brian, is there a way we can get a copy of this?
Yeah, I will post. I will post this particular one again in the WhatsApp and everything. But you should the link that you all had before, if you refresh it, it should show up in the Google Drive for download. But yeah, I will upload this again in the chat. But this letter is very powerful. Like basically, this is like the go-to letter for any debt collection. You have a debt collection, you just send this. I don't care what it's a hospital bill, medical bill, a repo. It doesn't even matter. If it's a debt collector and a debt collection, this is the go-to letter. Okay. That's the go-to.
For the lawyer too?
If you have a lawyer trying to collect something?
Yeah.
Yeah. I mean, now I discourage dealing with lawyers. If you have a lawyer coming after you, I do not discourage. I mean, it's like fighting. You know, you might be able to fight Ken because Ken, you're not a professional boxer, are you?
No.
So if you want to box Ken, fine. But if Tyson come in there, I will not suggest you box with Tyson.
Yeah.
It's just an unfair advantage. Even though he's older, I would not do it. Now Evander, he looking crazy, so you go ahead if you want to. Okay, so default.
I got a question. What if it's like a law firm acting like a debt collector?
Yeah, they still lawyers.
Okay.
That's like Tyson acting like he a chauffeur. You still don't want to fight with him. It's just not a good idea, you all. But to answer your question, actually, yeah, you can. Let me tell you, I use 1692 GB letters against other lawyers. You know, it don't matter. But I'm a lawyer, so I just don't suggest it. But if push comes to shove, yeah, that's what you can use. Just because I don't suggest it doesn't mean you can't. You know, what if I'm not? Yes, it can be used for that. I'm gonna say it like that. Yes, absolutely.
Brian, since the system isn't working, can you send me the email with the 1692 plus letter?
That's what I'm gonna do. Anybody that has that generator, it's been some technical glitches, so I'm gonna send you. There's a 1692 GB plus. The 1692 GB plus is a variation of the 1692 GB. It has additional language, and also you can CC it to me to let them know that you already have a lawyer like on speed dial. So that I am gonna, yeah. If you have the 1692 GB plus generator, I'm gonna send you that letter, and you can just draft it, you know, and use it until we get that technical glitch done. 1692 CC is not a letter I typically would use. Vance has had a lot of success with that letter. That letter is a sneaky way to basically initiate 1692 CC, which is communication, which means after they get this letter, they're not supposed to contact you. Okay, after they get this letter, they're supposed to cease communication except under certain small conditions. They can actually contact you to tell you they're not going to contact you. They can contact you to tell you they intend to do some legal remedy that they actually going to do, and that's really it. Or contact to tell you they got it and they're not going to contact you. So anyway, the CC letter, that does not come with the bonus letters. It's a specialty letter, but it is available. But that's the type of demand you can do. You also have what's called specialty demands, okay? You know what I mean by that? So specialty demand is a student loan. Now, if you have the specialty demand, can you still use the 1692 GB letter for it? Yes. The 1692 GB is a cover-all letter, But if you have a specialty demand, there are options out there for you because these are specialized areas. So what I put together some specialty packages. Like there's a student loan package. A lot of you have that. There's a repo package. Does anyone have that repo package? Our student loan package?
Yeah, I've got it.
So Warren, you take a look at that. And what about Warren? You probably have a credit card package.
Well, I got them all. So
you look at that, you see how different that attack is versus a 69. It's a completely different attack because there are different laws that apply to student loans, different laws that apply to repo, additional laws. Now, we say different, but you have 69GB, but a repo also includes UCC. So I say different, but I'm saying I should say additional laws. So the same laws for the credit card debt collector, 1692 GB, everything still applies, but you also have some Code of Federal Regulations that apply to credit cards, 12
Is the
CFR.
credit card that for charge-offs or just collections?
Any credit card deletion. It could be the credit card deletion. Actually, the credit card deletion package actually has two sets of things. It has you trying to delete it with the original creditor if it's not a debt collection, or if it's with a debt collector. So you can delete it as a charge off dealing with the original creditor, or with a debt collector that bought it or is trying to collect it as a debt collector.
Okay.
All right, so that's the demand. I showed y'all one demand, and like I say, these different packages, those are some other things. Step 3, I think we might make it. Step 3, well, first of all, that demand, let's go back to it, just in case. Let's go back to it real quick. What are we asking them to do? You see right here, let me see, can y'all see this letter? Let me see.
Yes, I can see it.
Okay, so keep in mind, this letter is asking them to do a couple, 3 things. Stop collecting. That's what cease and desist collection activity. And delete the credit reporting. 2 things, really. If you ask them for money, it would be 3 things, but stop the collection and credit reporting and delete the trade line. All right. So I just wanted to say that because if they don't do that, if they still trying to collect it, then you got to go to the next step. Y'all with me? So we're not going to go, we're not FES, we're not Lexington Law. We're not going to send this letter 12, 13, 18 months. Isn't that right, Ken? We're not going to do that. You're gonna delete it and stop collecting. And most people are very successful with that. Now you have a few debt collectors that are stubborn and want to act crazy and send you some statements or some crazy stuff. If you want to, you can give them one more chance, and maybe say, look, I'll give you one more chance. And by the way, for me giving you one more chance, you can go ahead and just send me $1,000. But if they don't comply, sue them. Okay? Sue them in small claims court.
So, Brian, should you sue them and submit a complaint to the Consumer Financial Protection Bureau, or just
okay? I'm sorry. That letter is going to go. That demand letter is going to go to the CFPB. You saw on there, we have their fax number. You're going to send that to the CFPB. You could fax it in, or you can go to consumer. You can go to CFPB, their website, or submit it online. So you complain online. Okay. You always going to do that. Why are we doing that? They're going to work alongside you very quickly, and they're going to contact that company and make the company answer to them, and while you want them to answer to you. How good is it to go back to the CFPB and say, you know what, we actually just deleted that. We're not collecting that anymore. You you know how good they feel going back to say that they resolved it on your terms? You see, that's why we do that. So if you never send that letter without including CFPB, it's like having, a bodyguard go with you. It's like, it's extra help, free. It's a government agency.
Brian, real fast, doesn't that collection agency or that creditor have to be registered with the Consumer Financial Protection Bureau?
Yeah, so that's a good question, Jason. They actually do not, but guess what? If I were you, if what I do is include the fax number, email, because if they don't have an easy way to communicate that dispute to that debt collector, they will come back and say it's something. They will come back and say we couldn't contact the company. They're not going to work for it.
The reason I asked this question is because my fiance just had an issue with a medical improper billing. So I sent off a HIPAA violation, requested a bunch of stuff, sent it to Consumer Financial Protection Bureau, and they responded literally within about 3 to 4 days saying, look, this medical facility, this collection agency is not registered with us.
Yeah.
And so because they were registered, we're not going to investigate this.
Yeah, and that's unfortunate. Yeah, and like I said, I've seen that happen too. And so what I try to do is include as much information I can, because apparently, I guess an address just won't do it. They want to be able to electronically, they're not going to send a stamp. So, but yeah, I've seen that, Jason. And so to avoid that, I've been including emails, because I think at some point, the CFPB, their duty is to get that company registered.
Oh, absolutely. Yeah.
And so if you give them like their fax number and email, I think they will go ahead and facilitate getting them registered. And I think this is all electronic process, because they're not mailing letters. Now they will, as you may have noticed, Jason, they will mail you a letter.
Oh, absolutely.
CFPB. Yep. But I don't think they want to go through the steps of mailing those new companies letters. So they will. So anyway, it's a good point, because these letters, the demands, I actually email, fax, and I'll put that on the letter. And that way, if the CFPB wants to include them, if they're not on their database, they can do it pretty easily.
Okay, good tip.
Hey, Brian.
Yeah.
Better to, like I went online the other day and did an actual dispute online. Is it better to do it online than it is?
There's no difference. And I mean, like I said, I don't know how they do this over there, but they will take your letter and pull out, and they'll do it for you. I fax. I've only done it online maybe once or twice. I'll fax them my letter, and they'll take my letter, attach it. They'll pull out language. They do. I don't know how they do it, but they will do it. So it doesn't really matter. You can do it online and input the words yourself, or just fax it, and they will process it, pull out language, create the complaint, send it to the company. Company will respond. Any questions about that? But yeah, you definitely implement that CFPB. I'm even thinking about doing some additional CFPB type work, but right now I just give them the whole letter and let them deal with it. And we'll talk about some advanced CFPB stuff later that I'm going to implement. Suing small claims court, KISS. What's the KISS method?
Keep it simple, stupid.
Keep it real simple. And I'm going to show y'all real quick a complaint. Remember, you want to include a state law claim. And also you want to consider engaging counsel. I just remind y'all of that. You don't have to do that, but it's like, it's like me, it would be wrong with me not to tell you to at least consider that, because otherwise you go in there and get beat up. It's like, oh, you told Hoppo to beat me. Let me, so you got that, right? Sorry. So let's look at some complaints real quick. And I think we're going to finish at a decent hour. Let me see. Hold on.
It's 9:02 now.
All right, so we're going over. So if y'all got to go, it'll be recorded. It'll be in the room, but we're going to finish, obviously.
Last time we started at 8 and ended at 10.
Oh, yesterday, yeah, that was bad, but we're not going. Yeah. Wait a minute. It's It's 10:02.
We started at 9.
Oh, okay. I forgot. He Mississippi time. Okay. All right. So look, yeah, we're going over a little bit, but guess what? We're gonna close this. It's 692. So I'm gonna show y'all a complaint. I'll show y'all two. This one, you see how simple? So can y'all see it? It's a small claims court in Georgia. All right. I sued a debt collector where they are because I don't live in Rockdale. I just sued them where they are. This is what happened. This debt collector, Central Management Solutions, called me talking about I owe some money, what, $22,200 something. Have y'all heard of the store called Belk? Is that still open?
Yeah.
Yeah, I heard of Belk.
When last time you shopped at Belk, Edwin?
It's been a while. They got it. They got it down there.
98 for me, brother.
1998?
Yep.
Exactly. So, man, that's last time I shopped at Belk was probably 1995 or 6.
2010 for me.
Well, you're Mississippi, so you know. Y'all got all this.
watch it now, bro.
Nah. But you know, see, you're the small town, right?
That was a
no, big town.
Well, where I'm from is a small town. We have a mall. It has Belts. It has Sears, JCPenney, all that.
Yeah.
I have not seen a Belt since I've been down, in the country, sort of south.
Yeah.
So in Mississippi, I would imagine the malls, you got Belt. Okay, yeah, you go through Belt, but I just don't see it that much.
Yeah.
Nothing against the small places, but I'm just saying. But you not. But what city you in?
In the Gulfport, we the second largest.
Oh, you the big city. Okay, so.
Yeah.
All right. So anyway, they called me about. First of all, you called me about what? The Belk. Well, first of all, it's an old debt, right?
Yeah.
And alleged debt, and I knew right away it's some BS. And I owe y'all how much? I was like, oh, okay. They didn't say anything about it being out of statute of limitations and that. So, and I asked them who they were. And so you see what I said. I said the plaintiff, a consumer, received an auto dial cell phone call July 2019 from the debt collector for GE Capital. Its employee requesting $2,200 and something from me over a consumer debt. I refused payment and attempted to get the information, was given the entity's name and a false address on Peachtree Street because I looked it up. Defendant knew the alleged debt is invalid or past statute of limitation and failed to send. Oh, here we go. They failed to send me a notice. Y'all see that?
Yep.
I'm like, okay. So you know how tough it was for me to sit in this desk for 5-6 days, man. Well, I couldn't wait. I was like, I said I couldn't wait. But anyway, did they send me the notice? Nope. So I sued a butt. How much did it cost me to sue them? About $100. It's not on there. But anyway, we about to get through this, y'all. How much I sue them for?
$15,000.
Golly. Why so much?
Plus $96.
Oh, $96. That's right. How's my account? Why sue them? Lisa? Why sue them for $15,000?
I don't know, but I want to know.
Well, anybody will have a guess? I'm sorry for going over.
You can sue for $15,000 in small claims?
In this court.
In Georgia? I got to move to Georgia.
So anybody know why I put $15,000 on there?
That was the limit?
Punitive damages, right?
It's no punitive on the FDCPA. It's the limit of that court.
And that's small claim court?
Yes, small claim.
Wow. What do we have here in New York? 4,000?
Oh man, some places might be about 5.
Yeah, the max is 5 in them small claims.
It depends on which one. I forget. I don't do business there that much in the small claims. I don't file small claim stuff in New York. I go straight to the bigger federal court or Supreme. So But anyway, I sued for 15 because that's the limit of that court. Okay, they kick and scream when they see that. Now, why didn't I just put $1,000? I know that's how much the statutory is. Why didn't I put 1,000?
You're going to the max.
Yeah, man, put the pressure on them because they kick and scream. So let's see. Let me go. Central management, is that the same one? Yeah. Okay, hold on. We're almost there, y'all. Hold on. Oh, so what do they do? Did y'all hear in there any state claims?
No.
I didn't put any state claims. Why not? Because I don't care. I ain't really. Hey, I want you to take me to federal court because I'm different. Because that's a great place for me because that's where 90% of my work is in federal court. So yeah, I don't put state claims in mine because please. Okay. And how much does it cost?
Go ahead, make my day.
Make my day. Go ahead, make my day. How much does it cost to file a federal court case?
It's the same, man.
$400. $400.
$400.
So I got to spend 4 times as much to get into that court. Do I want to do that? Nope. How much does it cost them to remove that case to federal court?
$400.
$400. They gonna spend their own money. So this is what a removal looks like, you all. I hope y'all don't want to see this because you don't want to get removed. But this is the removal. So when y'all see the replay, you can look up these laws: 28 USC 1331, 1441, 1446. You can look at that if you want to. It's just, that's law stuff. But they removed the case. You can do that. That's fine. I just want y'all to see it. That's what happened. That's fine. And then after they remove it, they got to answer, right? They answer. Yeah. They go deny everything. What do they say? Denies everything. Okay. They go deny. Now, I knew I had them when the cats didn't even mention the bona fide error defense. I knew I was dealing with some rookies at that point. So anyway, that's their answer. We go get through. King got to go to sleep. And dang, what we got here? Notice the settlement. So they selling already. So long story short, they what they did with this one, y'all, is called an offer of judgment. An offer of judgment, I'll let y'all look up that later. Go to Federal Rule 68. It'll talk about offer of judgment. Basically, they said, oh, I'll show you what offer of judgment said. This is what it looked like. This is what it looks like. They said, we offer you $1,001 plus costs, okay, in judgment.
You better, if you guys are suing and you see this, you better take it.
So what did they do to me again, y'all? They called me. No, they called me talking about, hey man, you owe us from Belt from the 1990s. And how much did I spend to sue them?
$96.
And they offered me $101 plus the cost. What's the cost? How much cost?
$96.
All right. So should I take it?
Yeah.
You legally have no other option.
I got an option. I could not take it and try to. If I don't get that much, it's on me. But if you don't get it,
let's talk about on you.
Yeah. So what this means is, if you didn't take this and you win and don't get this much, you have to pay their costs.
Wow.
From that point on.
Yeah.
So,
from that point on.
Yeah. From that point on. So is okay. So the FDCPA only allows for $1,000. So they're offering you $1,001. So statutorily, you can't beat $1,001. And so if you don't take that offer, you choose to litigate. From that point on, you're responsible for all of their fees and stuff like that. So
we're going to have to run through it. So you can actually get actual damages. But again, they called me. And so, actual damages is pretty limited. Anyway, I accepted it. So under the rule, I have to file this. I filed an acceptance. I accepted it. I'll take it. That's a good bet. Okay, so we have to put a notice of settlement, and then I took it, and then so the court entered judgment in my favor for $1,001 plus $96. All right, got that? So they go pay. Now they paid me in 2 little money orders. I was like, what the world? So they gave me one money order for $597, and they gave me another money order for $500.
They were being petty.
No. They just probably some little rinky-dink company.
Actually, Brian, I know the owner of that agency.
You do?
And that guy, when I met him and had conversations with him, I thought he was one of the most crooked people that ever entered the collection industry.
I bet he is.
So,
trying to collect high school debt on a 40-year-old guy.
So.
I mean, golly. Tell him to call me again sometime.
Well, I
didn't say that we were friends, did I? I steer clear of people like that.
Well, if you see him, tell him to call me.
He didn't know. Hey, he didn't know what he was getting himself into.
Real quick, y'all. Here's another complaint. This company, let me see.
Oh man, I hate them.
You know them, Convergent Outsourcing?
I have them on a report today. I'm gonna go right back over and ask the client some questions. I can't stand them.
You know what they did to me? They wrote me a letter talking about pay them. Can y'all see this?
Yeah.
How much are they trying to collect from me? Let me see if I can do this.
$100.
Can y'all believe that?
Wow.
It costs more to file. It costs more to file a complaint.
Edwin.
Yeah.
Let me ask you this. Would you even think to sue someone trying to, before the night, would you even think to sue someone to send you a letter for $100?
Nope.
No.
Where's Jason at? I mean, Jason.
Yeah.
$100 collection letter. Would you even think to sue on that? What about you, Ken?
We wouldn't waste our time on that.
Hell no, that's crazy.
Ken, you think I wasted? You think? Am I wasting? Am I just being my Bernie Madoff self?
You know you were an attorney.
Hey, you go to brianponder.com. I pop up. Now, when Ken Google it, he sees Bernie Madoff. Hey, Ken.
Yeah, man.
$100 collection letter. Would you even think to sue somebody on that, bro?
Are you trying me as a consumer with a $100 collection letter?
Someone sent you a letter talking about pay me $100. I'm collecting on behalf of USI. I don't even know who that is.
Man, I'd ignore him personally.
That's what he's expecting to get that $100.
What did I do?
So,
but I'm saying,
why would I do that?
You're
Why would
not
I
the
sue
ordinary
someone?
consumer, though.
Well, y'all not ordinary now.
That's what I was asking. Right.
But you're not ordinary now after seeing this. Well, you ain't seen the result. So I sued them. All I said, they alleged I owed them. And basically, I don't. I don't owe them that amount by law or any agreement. I don't know who that is. $100. So how much it cost me to file that?
about $100.
Same thing, about $100. Okay, $106, whatever. They removed this case, y'all. So they gonna spend $400 to remove it because I'm suing for $15,000. So they removed that case. Am I mad at them? No, thank you. Spend your money. Then they answered late. They tried to calculate the time wrong and they answered late. So I filed a motion to strike their answer. See, that's why I don't want y'all in federal court. You don't have to do all this. In small claims court, you don't have any discovery, motions. There's not allowed. It's not allowed. So anyway, I filed a motion to strike their answer. Long story short, we end up settling. How much we settled for, Ken? Let's see. Hold on.
$1,001, you said. Plus,
that's the last case. Can you read that?
$2,850.
Can you read this at the bottom?
Oh wow.
$2,850.
What you think about that, Ken?
Hey, listen, man. That's a good use of your time, baby.
Oh, I know.
Can they pay the mortgage that much?
Because I know it didn't took you no more than 30 minutes to type that mess up and electronically file it.
I didn't leave this office right here.
There you go. Push the button and send it to the court.
$2,850?
How long did it take for them to set a time frame?
I have to pull it back up, but we're talking about within small claims moves fast. So within a couple months, within a month or so, or two, $2,850.
I thought they had a database of people who to mess with and who not to mess with.
Hey, I guess I ain't make it yet. Ken. So anyway, okay, that's that. So let me get out of here. Hold on, let me go back. We about finished, y'all. Sorry for going over. But this is good stuff. I mean, look, this is good stuff. I mean, y'all can pay some bills with that. I mean, I'm just showing y'all the way. And look, let me tell y'all something. I did not, there's been no discovery, no court hearings. This is just off of the strength of getting their butts in court and catching them on the violation. So that's that. Part 4, we wrapping it up. What does that say, somebody?
Settle and prepare for trial.
So after you sue them, they go try to settle with you like that, right? If they offer you $1,001, what you gonna do?
Take it.
Okay. If they don't offer you anything, what you gonna do? Prepare for trial.
Go to trial.
Organize your evidence, like somebody was saying. Get your paperwork. Print that law. The violation you say you found, print that law. Look up some cases, study, so that you can articulate what's going on. Be courteous when they dealing with you, okay? Because sometimes, I know early in my career, I just had an attitude problem, and sometimes, they'll fight you just off of GP if they don't feel good. But just try to take a deep breath. And if you communicate with them, Mr. Mallard, what do we need to resolve this? Y'all know y'all wrong. F that. That's not gonna get you a check.
Yeah.
I know Ken gonna be nice to him because Ken, he cool, man. So be courteous. And I still have a problem with that. I still have to really, because it's frustrating. I just don't like lawyers and stuff like that. So I just be, man, I have to really try hard. And sometimes it doesn't work. So getting character, and what I say for that is, be nice, pretend like, be cool and collected. Don't be stressed for that money. Like, I know you may have some bills due and like, look, I'll take how much you need. I'll take whatever I can get. Now, be cool. Understand you need at least $1,000, but I'll take 5. I'll take 5,000. Well, why you want so much? Well, look, you wasting my time. Yes.
How long does it take if we have you do it? Like, what's the turnaround like?
Well, I was telling you this. It takes a few months. I mean, you never know. I mean, if it's in a small court, it's designed for fast track. These small courts, big court. If it goes to federal court, well, that thing may take 6 months, 8 months, a year or more. So you really don't know. If it's in a small court, those courts are designed to be heard. Have you heard within a couple months or so. So it all depends. So you really don't know, but get in character and everything. And remember, pigs get fat, hogs get slaughtered, right? So that's why I got a little pig on there. If they offer you $1,000, well, don't be thinking about Vance, because Vance, some of his cases, okay, he may get $5, $10, $15, $30,000. Well, Vance has been doing this as long as I have. So don't look at Vance's check talking about, well, Vance had an inquiry case and he got $10,000, $15,000. Well, that's not how you operate. If they offer you $1,000, $1,001, take it. See, I was able to get 28 out of the other company. Isn't that crazy? Because statutorily, I would have had to prove that I got that much in damages, but I was able to get it because you stay cool, stay in character, poker face. Any questions about that? Preparing for trial?
My last question is, I ordered a demand letter, and I was just wondering how long that takes for you to get back with us.
Which one?
I ordered a demand letter. It's been a minute ago.
Oh, well, yeah, you can do it whenever yeah, it can be done immediately.
No. I'm saying I ordered one back May 4th, and I haven't got it yet. So I was just wondering how long.
Oh, okay. Well,
I didn't want to bug you.
I'll probably need some information from you. So just email me tonight or tomorrow on who it's going to go to. You need to tell me when you do a demand, you just have to give me the information like who is to and stuff like that. So you can order it, but until I get the information, or if you sent it, let's resend it, and that's all I need, who it goes to, and we get that out. So as Ken was alluding to, these letters, at least the templates we talked about tonight, everything except 1692C, y'all can just grab, most of y'all already have my book, but yeah, a lot of this stuff, the 1692GB, the CRA dispute letters, all that stuff, inquiry deletion, that's in the book. And then you just email me and I send you all those templates. You email me, I send all the templates to you. You email basically your receipt from your purchase and then you get all that. But yeah, most of y'all have that book, but yeah, get those templates, use that. As many of you know, I have those specialty packages. So I have a student loan deletion, credit card deletion, repo. You can just email me if you want those. Those are separate. But yeah. Let me see. What do I have?
How much is the repo package?
What's that?
The repo package. How much is that one?
Oh, I think it's $197 at this point.
Okay.
But yeah, so if you need those, you can just email me and tell me which one you want. I'll get it, get it to you. But any Q&A, sorry for going late. It's really tough, y'all, to get that thing in an hour, but I wanted to get through this. This is, you see, Ken, we can pay some bills with that $2,800, can't we?
Listen, man, I can take me a nice trip to the DR, baby.
Listen, that'll get you there. That'll get you some food and everything, whatever you need. Get back.
Yeah, baby.
So that, listen. So when we hang up tonight, you're not gonna look at these letters the same. You're talking about just ignore that letter? Shit. That's no. Let me see. We got some chat questions. A divorce proceeding. Anybody got any questions for me? Let me see.
All right. So
yeah.
When I sent out the 1692 GB, how long do they have to take for their response?
You know what? That's a good question, because do we put a date on your consumer edition? I don't know if we. That's a good point. Maybe we need to put a date. How long do you think I give them on my letters?
72 hours.
What you think, Ken? How long I get these debt collectors?
I thought I saw somewhere you said 14 days.
I used to give them 14 days. Now I give them 72 hours.
My.
Huh?
I said, oh my, man.
Why I give them 72 hours? That's enough time. All you gotta do is press a button, man. I've got time. You don't take you 2 weeks to do that. And I'm trying to get this money. I can't be waiting. Since Ken canceled on me, I gotta get that money some kind of way.
Hey, but listen, man, you need to get up off of me, man.
No, tell him, Edwin, it's gonna be okay, bro. It's gonna be okay. This is the last day. I ain't gonna do you like that no more. You ain't gonna do you like that no more. Everybody, can we all just get along? We go.
I mean, goddamn.
I'm just playing. Let me close this. But any other questions? And again, we went over, but look, sometimes, it is what it is.
This 1592 CC letter. After you send that letter, can you initiate a suit, or do you send another letter? Or
okay, so listen. So the 1692 CC says, y'all look it up, 15 USC 1692 CC. So after you send that letter, they can't communicate with you anymore. And we're gonna have to talk about that Santander case later. But if they contact you, boom, you got them.
Okay, I got a question when you get through.
Yes, sir.
Much earlier in the conversation tonight, you made mention of the collector making some kind of violation by obtaining a credit report.
Yes.
If they step into the shoes of the original collector, what violation would it be if they pulled my credit report?
Okay.
But it's also
let me see. Let me see.
All texts are.
I had to mute Peter. Peter Piper over there. Okay, good question. So when you say step into the shoes, you're referring to a debt buyer.
Correct.
Okay. When a debt buyer buys a debt, that debt has defaulted already. And so technically they can be treated as a debt buyer. But let me tell you this. I will give you a real answer. It does not really matter. They still need a permissible purpose, because even if the debt buyer or debt collector, this is yesterday's lecture, but they're going to have a permissible purpose. They're going to say it's for the collection of an account. But if you look at yesterday's lecture, the account as defined in the FCRA is not the account they're collecting. Let me see if I can let me just show you real quick. You follow me, Ken? So
I understand what you said wholeheartedly, but I understood what you just said.
1681B is a permissible purpose. It says a consumer reporting agency can furnish a report to a person that has reason to believe. Let me just skip. Review or collection of an account. That sounds all good and dandy. If you look at last night's lectures, anything that's blue, you click on it. Account is a special word. It's not just any kind of account. The term account means what it says in 1693. And to get to that, you go to AR4. So we click on 1693. It defines account as, what's out, Ken? One, demand deposit, savings deposit, or other asset account other than incidental. So what they're collecting does not fall into that category. And so that's really a specialized thing. This is a whole different ballgame, but it's crazy stuff. So they think they collecting on the strength of this, but when you look a little deeper, that debt they're collecting on may not be an account that makes it permissible under this. So you get intimate with this right here. And by the way, that's a bonus letter. You have this, the inquiry deletion letter and $1,000 demand on there, because if you see a debt collector pulling your credit report, all you got to do is send that $1,000 demand letter. They don't do it, you can sue them just like I did, and get some money there. But like, yeah, someone put in here $100 and $2,800. I'll take it. Shit, I'll take it all day. Any other questions?
Hey,
Yeah.
Brian.
Is it worth suing for harassment if the call wasn't recorded and they did in fact harass the consumer?
Well, I would go ahead and I would not, because it's hard to prove. And so once if they harass you once, they'll harass you again. Get you a call recorder app that will automatically record. I have one on my phone, but for some reason it stopped recording automatically. But yeah, get a call recorder app and try to get that call recorded again. But is it worth it? I mean, $100. I mean, you know, if I think you have a hard time proving it, because the judge wants to hear it. He's gonna hear you and like.
But they can subpoena their phone records. Is that correct?
What's that?
It could subpoena the collector's record, the phone record.
Oh, that recording. That recording is not going to be available.
No.
We delete. They'll have a policy made up where we delete, within a week or so. No, Jason's. Yeah, they're not going to incriminate themselves.
So I'm going to ask you a question there, Brian. Do you ever try to negotiate with the collection agency, just, item A, B, C, D, like a whole laundry list of violations, and say, hey, you want to settle this out in court before I... As far as a good faith letter to them, and say, hey, look, I don't want to sue you, but I will. Here's a list of what all the violations I've got here. Cut me a check. Because when I was a manager at the collection agency, we did that all the time. It was less expensive for us to just write a check and make the matter go away, rather than have it go to a district, superior, or a federal court.
Okay, so y'all listen.
Yeah.
So
hey, what company did he work for?
Viking Collection out of Minneapolis, out of Minnesota.
So,
man, I need to do some marketing against them.
Right. We need to holler at them, right?
Right.
So here's the thing. In the consumer letter I give y'all, I don't ask for money then because they're violating you. In the letter I do, typically the consumer is paying me a small fee, and likewise, I don't ask for money. I just ask for the deletion within 72 hours, and we're good. If they don't delete it within 72 hours, then we have a problem. I'm gearing up to sue you. And, but if you're not doing it, if you're not deleting it, because I give them an option, you can delete it or you can go through that whole verification process and try to prove your rights of what you're doing, that you're doing is right. So, Jason, I typically do not posture. Sometimes I do. I'll tell you like that. Sometimes I do. But for the most part, my course of business is I'll take a small fee from the consumer and just make that thing go away. Because we talk about, I made debts. They could be 10,000. They could be a huge debt. And to the client, that's awesome. That's what they want. And that's how I usually do my business. But if they don't delete it and I have to sue them, yeah, we're going to have to do money. Now, even if they have a violation that's clear and I write them, I personally think they see that I have a good amount of melanin and like, okay, fuck him. Because, my other friends may get a settlement. So I just prepare to sue. And once we're in the ring, it's like, oh shit, okay.
Okay, from the standpoint of a consumer, for business owners out there that are helping out individuals and standpoint of attorney separation on that. Now, what I've seen in the past, literally 5 to 10 years, when a consumer sends out a overall cease and desist, silence, don't contact me whatsoever, I see a lot of those cases going straight to a lawsuit from, a collection attorney on that. So what do you see as far as the percentages when you send that out? Does your lawsuit or this process pretty much trump them and stop that? Do you see a reduction in that occurring when they know that there's a lawsuit right away?
A reduction of what occurring? Yeah.
Well, again, if it's a typical collection agency or collection attorney, debt purchaser, whatever the collection entity is, a lot of times when they receive a cease and desist, if it's overall where you can't contact me by mail, by phone, no communication, I see a lot of those cases going directly over to a collection attorney to file suit against that individual. Do you see a lot of cases like that?
I see what you're saying. Oh, okay. Well, first of all, my templates don't talk about cease and desist. It says you need to stop collecting and reporting and all that and everything. So I don't see it trickling to like a collection law firm to sue the consumer.
Yeah.
No, I rarely see that. I mean, I haven't seen that much from my end. At least people that have used the 1692 GB. The worst case scenario I've seen is sometimes they may send some statements and try to be all cool, like they can verify the debt. Now I do warn. It's a good thing to warn people that. The reason I kept saying consult a lawyer, because a lot of people, when they start disputing these debts or waking up, these people may not even know where you are. Like Jason, some of these people, they were find them, couldn't even locate them, return mail. And so when you become a magical credit repair, I'm going to repair my credit. Well, you just let them know where you are.
Oh, absolutely.
And you're going to get sued. So I warn people about that all the time. This may work, but it also may backfire, like Jason is saying. It will backfire because, I know where she is, and she must be trying to get her affairs in order. This is a great time to pounce on Miss Jones.
Yeah, that's definitely good advice for any professional out there that's helping out consumers with their credit.
It's very dangerous.
You may wake that giant.
Yes.
Because they're looking for that. They're monitoring those credit reports. They're skip tracing people down. And one of the things that I advise my clients on is like, shut your social media down. shut everything down. If you're trying to improve your credit, chances are if you have outstanding collection accounts out there, last thing you need to do is hand them your new data on a silver platter. Don't make it easy.
Yeah, exactly. So before I had a falling out with like Legal Shield.
In that case,
What's that?
if they get a lawsuit because you start disputing, do they go ahead with it?
What was the question?
When you send a dispute letter, and like you said, you wait the giant and they find you and they send you that court papers.
If that happened to one of you all, I would say awesome, because I would suggest you counterclaim, and that's your free ticket into court. Like, great, okay, here we are. Instead of suing them, you would just counterclaim, and usually when you do that, they'll want you to just walk away, but you can even get money from them. But that's a serious consideration. And that's the whole point of this education, because if you do this blindly, a lot of people just buy this stuff, these templates, and just to hurt. It's going to hurt you. Like Jason is saying, you could be opening up, Pandora's box, and you may get sued because now we know who you are, and we know you're interested in cleaning up your affairs. I see you outside in front of your BMW.
Exactly.
So, but yeah, that's a good consideration. And, you all won't be afraid. Like I say, if someone sued you all, you actually probably be sort of happy, like, oh, great, I'm going to countersue their ass and get some money out of them, make that debt go away. But, if you're helping people, they really should, highly consider consulting, having that, be prepared for what Jason is talking about happening. What if you get sued? Do you have a consumer lawyer that can service that client? That's what you suggest. And also, I suggest for credit repair people that you advise people of the possibility that they're high risk of getting sued in the process of fixing their credit, because it's going to update their address. It's going to show their credit is improving. And now that debt collector may understand that, oh man, this is a good candidate for someone that might want to resolve it. Let's sue them, and I'm sure they may work out something.
Froze for a second.
Anything else? Oh,
yeah, I had an.
Say it again.
How do we make sure that it doesn't get removed into the federal court when we file the?
Okay, we talked about that. Who wants to tell her that?
State law.
For the state law.
Include a state law claim, always.
What do you mean by that? Include a state law claim?
Okay, who's talking?
Tony.
Yeah, so a state law claim is a non-federal claim. So it would be, some states have companion debt collection statutes, companion credit reporting statutes, consumer statutes. You include that, find that. You could sue for defamation if they're reporting your credit because they're affecting your reputation. You can sue under negligence, saying they had a duty to do something, they didn't do it, and it hurt you. And so that will keep it from being able to be removed from a small claims of state court or federal court.
I heard you mention that. And so is that the same type of things that we would sue for in a counterclaim?
Yes, exactly. You would do the exact. So if you were to get sued, you would deny what they're doing and basically sue, just like the lawsuits you saw me do. That'd be called a counterclaim.
Okay. And then I recently had a client, she got some bad advice from another credit repair person, and they basically told her to pay off all her debts.
Oh, Lord.
And yeah, it was like $12,000. She's already in payment arrangements with these people. And so she, like most consumers, ignore, some of them were judgments actually from earlier in the summer. And I was on another call, and an associate was saying that they went ahead and filed some things to go ahead and revoke those judgments. Is that something that, if I'm knowledgeable about that, I'll be able to help my clients do? Is that
who filed something to revoke judgments?
Just an associate. She's a credit repair person.
Yeah, well, she's out of compliance. I mean, that found stuff in court for a person. Now you. Oh no.
Well, she didn't do it. She basically gave them the disclosure and stated that.
Yeah, that's too much. She's doing. Tell her. I said you're doing too much, girl.
Okay, so what would I suggest to that client or any clients in a similar situation that already have judgments against them from them ignoring the debt?
Fair question. They should consult an attorney because that's in the court. Just like, thanks, Jason. We're way over time, and this will be a recording in the Facebook group. But I stick around. I come sometimes before, sometimes after. So, thanks, Jay. Anytime, that's a good point. Anytime someone is sued, or anytime someone has a judgment, I advise they consult with a lawyer. It's gone to the Tyson stage, to the Mayweather stage, because you can't. I know it's not right, but you can't legally consult with them. You can get their power of attorney and do stuff for them, but you can't legally consult them on how to vacate that judgment, because even the words you're using is vacate judgment. So you don't want to ever be caught up consulting something. Not that you say anything wrong, because you're gonna know more than anyone else. It's not that what you saying is wrong. It's just that if they rely on it or act on it and do the wrong thing, they're gonna say, well,
Tony told me.
Tony told me this, she told me this. So yeah, anytime a lawyer gets involved with your consumer, they get served a lawsuit, don't try to answer for them. You're gonna know how to answer. You're gonna know how to do a lot of stuff, but that doesn't mean you should do it. Like your lady that I say is doing too much, what she's doing may not be wrong as far as the procedure, but if anything goes wrong, she's gonna be held criminally liable, because it's like, I don't think it's right, but they have unauthorized practice of law as a criminal thing you doing. So you don't want to ever advise anyone on how to deal with judgments or lawsuits, other than advise them to get a lawyer, consult a lawyer with that. And that's why every credit repair person should know a lawyer that could service that client. So if you're doing clients in New York, well, look, you're looking at a New York lawyer. So if you're serving clients in Mississippi, everyone needs to become friends with a consumer lawyer. Go to consumeradvocates.org, look up some of those lawyers, and say, look, hey, I may have some clients that may need some debt collection defense. So you need to have someone in every state that you service that perhaps can service clients, because the clients are going to expect you to. If they get sued,
exactly.
I don't know anybody. They go like, what? That's your industry.
New York is a class D or E felony in New York, practicing without a license.
It's crazy. Yeah, and it's crazy. So even advising, people think, well, I just help them.
Why you get you?
Same thing.
I'm in New York.
Yeah. So anything in New York, I'm good. But yeah, so y'all got it?
Do you have a referral in Texas?
Yeah. Yep. Sure do.
You got one for Chicago?
I have to look at my little Rolodex, because I did meet some colleagues at a conference up there that helped. But consumeradvocates.org, I'm not really that active in it anymore, but it's that's where I'll put it in a group, I'll put it in the chat too.
Do you practice in Georgia?
No, I have someone in Georgia that works under me though. That's yeah, so I have someone.
My clients are from Jersey and Philly, New York.
What's that? Jersey,
Philly, and New York.
I don't know anyone in Jersey, but yeah, New York, I'm the man. All right. Anything else? I know, let me see, Warren, your wife's asking what's going on. She's like, you need to go to bed, bro. You need to go to bed. All right, so yeah, go ahead.
I sent out the $1,000 demand letter. I sent it certified. I see they received it. They signed for it. That was on the 12th of May. So of course I gave them 14 days. If they don't respond, is that once I can go ahead and file the suit?
Yeah. Now, are you the one that gave me about a dozen of them?
I have a dozen of them to send to you.
Oh, okay. Yeah. So if it's a debt collector, yeah, it's good to send it. Give them 14 days. If they want to talk crazy about some account stuff, they just sue, because they don't have the luxury of FDCPA trying to say it was an error and all that. Now, errors on the FCRA side is money. That's negligence. So, but yeah, you give them that time period. After that, yeah, it's wide open to sue. Go ahead and get this money.
Do you have a package to follow up after that? Like, do you have a package?
I'm almost, yeah, I finished almost that inquiry deletion package. By tomorrow, I'll probably have it available for sale. It's basically the letter series and then the lawsuit and then, some settlement.
Is it in 197 as the other one?
Yeah. And y'all better get it fast because that price be going up.
Don't you have a bundle for like all of
my birthday last month, but it's gone. That's gone.
So those of us that got the bundle, you're just gonna send it over.
For those who got the bundle, I just send it over because I got 15 coming out. I mean, so the
I'm new,
information.
so make an exception. We're new. What about the new ones?
What's that? New people
that never got the bundle.
I don't know. Y'all might have to come together and make me an offer or something. I don't know. I might want to talk amongst yourselves and like, look, let's offer him. Let's 10 of us just say, hey man, we give you 420 and we got like 20 people give you 420. Will you take it? Y'all come together and do something.
That's how you do it.
Work it out. So
hey Brian.
Yep.
I have a question just about that. I saw an article. I think somebody else posted it in there about Santander.
Yeah, we'll talk about it.
And you are? Okay.
I haven't read it. We'll talk about it another day.
Okay.
Y'all don't want me to go to bed, do you?
Nope.
Edwin, they want me to go to bed. Who's just talking? Who just right here?
Latia.
Somebody got that little glamour shot on here. Hold on. Let's see.
That's Latia.
Oh, that's Latia right there?
Yeah.
Hey, Edwin, where's she at?
Georgia, ain't it?
Yeah.
Atlanta?
Yeah.
Yeah, you gotta watch Edwin. It's late. Y'all already turned the camera off. I see them. All right now. That's that Olin Mills type shoot right there. All right. So look, y'all, we're going to bed. We'll continue this later. Y'all act like I'm about to die tonight, man. We got tomorrow. What's the day? What's the day? Wednesday? Oh,
Wednesday.
Yeah, I might do something tomorrow. We'll do something short tomorrow, real short. Maybe a Q&A tomorrow. We'll do it real short. But did I show y'all how to get to the money? I showed y'all the money. Y'all don't think I'm playing. Y'all think I'm playing. That's all.
Okay. Thank you, Brian.
Oh, you're welcome.
All
okay,
right.
y'all.
Good night.
We good. All right, y'all. Have a good evening.
Good night.